Hello, everyone. Good afternoon. I think you would be able to see and hear us clearly, but if you can't, you can drop a note in the chat. My name is Linda, and welcome to the APAA Short Training Courses webinar on AI inventions. For those of you who are new to APAA, APAA stands for the stands for the Asian Patent Attorneys Association, which is an NGO established more than 50 years ago with the objective and to promote and enhance IP protection in the Asian region. And this includes New Zealand and Australia as well. So this afternoon, our panel of expert speakers will discuss and highlight some of the pressing issues presented by AI inventions. Definitely a very current and probably a topic that needs to be discussed more than before. When we use the term AI invention, for me anyway, it tends to conjure up an image of a super smart robot-like person coming up with, inventions that are not humanly possible. But if we come down to it, actually, AI is essentially a computer program that has been, of course, a very sophisticated program that is designed to mimic human behavior by learning data, patterns, and insights. And that's in a nutshell. Of course, I was discussing with our speaker, Cyril, just now, that there is soon, well, I wouldn't say soon, but definitely a possibility that we may come to a stage where, the AI itself can generate the invention. But so far, most of the AI inventions that we've seen or that have come to court or that have come before the patent office are inventions that have resulted from efforts of both human and machine. You would, logically need human input because you need, well, first of all, there has to be a definition of the problem. You set up the problem, and then you guide the search for solution to the problem. And lastly, you have the AI doing all the, data churning and producing results, which then needs to be interpreted and then maybe fine-tune or tweak to come to the invention, which will be a solution, a real solution to the problem. So at this stage anyway, it does look like that without human input, the AI program is incapable of AI inventions. So without further ado, I want to quickly introduce our speakers to you. You have already seen their impressive credentials in the webinar brochure that we've been sending out. So I will do a very brief introduction here. Dr. Alexandra George, you will see her book cover avatar. She is a IP law specialist and an associate professor at the University of New South Wales, Australia. Alexandra has a particular interest in AI inventions and has published journal articles on the topic, including the publication entitled AI is Breaking Patent Law. We also have with us Mr. Hemant Singh, a famous IP litigator in India. He is also the managing partner of the IP boutique firm INTTL Avocare, with offices in New Delhi and Mumbai. Hemant has the experience of having handled more than 2,500 IP court cases under his belt. No small achievement indeed. And last but certainly not least, Mr. Cyril Chan, a foreign counsel and US patent attorney with the reputable law firm Kim & Chang, based in Seoul, Korea. Cyril brings with him valuable IP experience, both in-house and in practice, with a particular focus in patent litigation. So moving on quickly to the first issue, I think a very glaring problematic issue with AI inventions is ownership of the patent rights relating to AI inventions. Now, who would count as the inventor of an AI invention? The two, inventorship and ownership, are necessarily interlinked because under the patent laws of most countries, it is the inventor who has the initial rights to a patent. Alexandra in her articles have posited that could it be the person who wrote the AI program? Would it be the one who owns the AI program, or the person who commissioned use of the AI program to create the invention? Who would have rights to the invention that results from the efforts of the AI? Perhaps Alexandra, we may hear from you first on this issue.
Oh, thank you very much, Linda, and it's a pleasure to be here. I thought I might just start off by talking about the case that has brought this all to the fore, because it's a really vivid illustration of the issues that are starting to arise in relation to patents and artificial intelligence, robots, if you want to call them that, systems, and the real challenges that these developments are bringing to patent law as we've known it for centuries. So this question of who owns the inventions, who owns the patent, comes about in every case that we ever see in patent law, but normally it's just maybe there's a question about, was it the employer or was it some other person who's acquired title through the inventor? But when we're talking about an AI generated invention, then that raises some interesting new questions. So as Linda said, the default position is generally that the inventor is the first owner of the patent. The inventor does something that brings about the new thing that is worthy of being patented. And then, of course, the property rights come about through the registration process. The first inventor or the inventor is named on the patent application as the person who has done that creative, inventive, novel thing. And then you might find that their employer ends up being the owner, or perhaps somebody else has derived title. Maybe they've assigned their ownership to an investor or a grant body, or maybe they've started off owning it and then sold it on to somebody else, assigned it. So there are various ways in which you can end up with somebody other than the inventor as the owner. But that's in the normal situation. In our AI generated invention situation, it raises really interesting questions, because if you think about it, the patent laws that we have today are very ancient. The concepts that we're dealing with, the original ideas of a patent law, date way back to the Venetian patent statute. That's 1474. And if you look at the earliest British patent law, if you want to call it that, the Statute of Monopolies in 1623, you'll see that the wording that is found in that very old law is still found in law as well. Here in Australia, in the modern current patent law in Australia still has wording taken from the Statute of Monopolies. So go back to 1474 and 1623, when these concepts and structures that are informing our patent laws today and are the foundations of our patent law today, you go back and look at where they started and look around and try and find some artificial intelligence robots floating around. And there weren't any. There were some very inventive people around, but back in those days, inventors were human beings, and therefore patent law is predicated on having a human inventor. So now we have this situation where AI systems, AI technology is racing ahead. The development is coming on very, very fast. And it's against the backdrop of a law that has evolved slowly, steadily over a long period of time, where most of the challenges really about whether something is patentable would normally come down to whether or not it is novel, or whether it's met the substantive criteria for patentability, not so much whether or not there was an inventor in the first place who could be recognized under patent law. And so this has all come to the fore in the last few years, because there's a patent cooperation treaty application that went in, and it's been sent out to about 130 odd countries around the world. jurisdictions around the world. And it's generally known as the DABUS series of cases, DABUS, which stands for Device for the Autonomous Bootstrapping of Unified Sentience. And the DABUS cases are testing this principle or this assumption that you would have a human inventor. And so the cases are brought by Dr. Stephen Taylor, who has, who's an inventor and who has developed this AI system, DABUS. And Taylor claims that DABUS has invented a new type of food container and a flashing light for attracting attention in emergencies. And so there are these two inventions. They're perhaps not there's nothing wrong with the inventions, they're perfectly fine inventions, but they're perhaps not the most eye-catching inventions straight off the bat. What's really interesting about this case is that Dr. Taylor has listed DABUS as the inventor in these patent applications that have gone out around the world. And so, it takes a little while for patent cooperation treaty cases to start working their way through the system. But now we are seeing, or we have seen and are seeing, outcomes in multiple patent registration authorities around the world, and also court cases investigating whether or not rejections of the applications were valid. And so I won't go through them all because there are quite a lot of them, but just to summarize, these cases are notably ongoing in the United States. So it's been, it's now on its second appeal to the Federal Circuit Court in the United States. In the United Kingdom, again, there's it's been dealt with by the Intellectual Property Office, then gone to the High Court, and then gone on appeal. And this is an attempt to get the Supreme Court in the UK to hear it. The European Patent Office, it went on to the EPO Board of Appeal. In Germany, Taiwan, Korea, New Zealand, Australia, South Africa. So this case is really being played out around the world. And so I'll just summarize very quickly before handing back to my colleagues here, how this is playing out. Most jurisdictions are saying, no, you can't have an artificial intelligence system listed as your inventor. It has to be a human being. And so that has been the outcome in almost every forum in which this has been decided. Notably, in Australia, in the middle of last year, there was a judgment from the Federal Court of Australia, which said, actually, we will recognize that an AI inventor could be named as the inventor on a patent application. So that caused a big stir around the world. It was a really interesting decision, very philosophical in parts. And, for an academic, it was an absolute delight to think through all the issues and read it. However, it was overturned in a full court decision, full court of the Federal Court of Australia earlier this year. And that was an interesting decision because it was a very distinguished panel of judges. It was the Chief Justice plus 4 intellectual property specialist judges, which is a pretty hefty weight of intellect that was coming to look at this question, and larger than your average appeal case in the full federal court, where you normally have 3 judges. So that overturned the outlier decision. The other 2 decisions that have been sort of outliers have been in South Africa, where you had actually a day apart from the original Australian decision. You had a decision or an outcome that your artificial intelligence system could be named as the inventor. However, this was just an administrative outcome. So it didn't actually go to examination. And so, it could stand to be examined and reversed down the track. And the other one that's quite interesting was in Germany, where it went on appeal. And there was a kind of a compromise situation there in the end, where they said that you could acknowledge an AI system's input in your application by naming the AI system, but alongside your human inventors. So this brings us to this question of who gets the rights if you were to have an AI system listed as the inventor. So it's not that we're there yet, but it might not be too far off. And so if we did have, for example, a situation like the original Australian finding court decision would have led to, who would you have given your ownership of the property to? So you name an AI system as your inventor, who ends up being the owner? You could have a situation where the person who created the AI system, well, it's probably not one person, it's probably a group of people, and maybe it's going to be difficult to work out who all those contributors are. Perhaps they get rights, perhaps the person who owns that system gets rights, perhaps the person who instructs that system how to invent or what to invent, sets out the parameters for their invention, gets rights. Perhaps the people who have written all the material that's covered by copyright that has been fed through the AI system, that it has built on, you know, the giants whose shoulders it has built on, perhaps those people get rights. There are a lot of different possibilities, but you can see that it takes us outside our traditional thinking about who ends up being the owner of a patent. So at this point, I might hand it back to Linda to moderate, and to my colleagues who are the practitioners who might want to comment on the idea of who would and should be getting the rights.
Thank you, Alexandra. Yeah, so it's looks like what you're saying is that what we have today is not enough to support AI as an inventor. Perhaps we'll hear from Herman and Cyril on this matter.
Yeah, thank you. Thank you, Alexandra, and thank you, Linda. I think that if you look at the judgments which have been delivered by the Federal Court of Australia and the UK Court of Appeal, we are fortunate to say that we have reasonable guidance as to how the courts have evaluated this issue. And I think they have analyzed it beautifully, because they have not just looked at it in a very technical manner. They have looked at it in a very holistic manner, and they have gone and examined as to what is the objective behind conferring patent rights and whether that objective is getting compromised if we start considering AI as the inventor, which is a machine. So let's evaluate that. Patent, as we all understand, is basically a reward which is given by the state for the inventor to disclose his or her invention, so that the members of the public can take advantage of it once the patent expires. Now, that reward is form of an incentive. Now, if you do not recognize human as the inventor of an AI and give him that reward, then where is the incentive for a human to create an invention so as to secure a patent and exploit it? That's one. I mean, if we are recognizing AI as the inventor, then where is the incentive? Number one. Number two, jurisdictionally, the right which is conferred in respect of an invention is on inventor, unless the inventor assigns the right to an applicant, and then the applicant becomes entitled to apply for the patent. How do we achieve that? Because an AI cannot, a machine cannot assign. So what happens in such cases where AI is the inventor and cannot assign it to a human? Number three, right which is conferred, whether by a Patents Act or any other act, is secondary. First, a right is conferred by constitution on an individual or a citizen or a national of a country. the law requires, the Constitution requires that that right must be protected. So if you look at constitutionally, a right is always recognized, conferred, and protected in a human and not in a machine. So that's on the juristic part of it. Now let's talk about the technology. The AI, as I understand, is a machine which is a creation of a human. A human, an inventor, is the one who creates an AI, right? Now that's one invention. The AI itself is an invention, in which case I believe that the inventor who has created the AI is a human and is a inventor, and there's no difficulty there. But where the AI creates an invention, which is not by itself, I mean, I don't think we have reached a stage where the AI by itself is creating. As I understand, AI creates an invention based on how AI is programmed, what is the data fed, and various parameters which require huge amount of technical skill, which a software developer has. And therefore, it's the developer or the software engineer who has enabled an AI to create an invention should be considered as an inventor. So to my mind, whether we look at it juristically or whether you look at it technically or logistically, it should be the person, the human, who has contributed to the AI developing an invention should be considered as an inventor.
Right. Thank you, Herman. I think what you are saying is that the AI is simply a tool, and it's really the people who, just like any other inventions you have, you do use tools to come to your invention. So it's really the person who had used the tool, or who has knowledge to use the tool to create that invention, who should have rights. Alternatively, is the person who has paid, the person, or who has commissioned the person who knows how to use the tool to create the invention, who should be vested with rights. Cyril, what do you think?
Well, I agree with Hemant and Alexandra with what they said. I'll just kind of play a little bit devil's advocate and talk about some other views that I've heard that makes this question of inventorship and ownership kind of a controversial issue. Well, first of all, for inventorship, the key principle behind it is, who conceived the invention and who contributed to the inventive concept. So among AI inventions, there can be a wide spectrum of different AI inventions. There can be AI inventions where the human actually did a lot of work. They had to program the AI model. They had to feed the model data. They had to do a lot of things in order to make the AI machine work, in order for the AI machine to, be able to develop the supposedly patentable subject matter. And then on the other end of the spectrum, with AI, constantly evolving and improving every year. Just look at like the chess technology, which it started to learn by itself. Just by playing by itself, it started to learn new ways of playing chess. So you have on the other end of the spectrum, you have AI technology where without that much human intervention, it can process data and then it can learn in its own way, and it can come up with solutions that might not entirely have that much to do with the raw data that was first fed by humans. So on that other end of the spectrum, I think when you go back to the idea that inventorship is about who conceived the invention, then I think it becomes a pretty difficult question, because if the machine actually really contributed to the core inventive concept, and the humans with the feeding the data and programming that didn't necessarily contribute to that core inventive concept, then that means the machine itself here in this situation, the machine itself is really more of the inventor, is really the one that really invented that core inventive concept. And so in that scenario, I think that's where some critics are concerned about, this is not an issue now, but in 10 years, in 20 years, who knows? But if AI inventions continue to evolve in this way, then the current laws are just cannot handle this kind of situation, because current laws, they require the inventor to be a natural person, and so then the AI cannot be the inventor and therefore cannot be the owner of the patent. But if no human actually truly invented that core inventive concept, then then there is you don't have an inventor for your patentable subject matter. So then I think that goes against the purpose of the patent system, which is to continually promote the advancement and progress of innovation. So if you have patentable subject matter that you cannot bring that to the patent office for a patent application because you cannot fill in who is the inventor, then what do we do in that situation? I mean, I think that's a question I'm not sure we can answer right now.
Yes, those are very interesting questions, definitely. I think probably needs an answer or solution sooner rather than later. In the interest of time, I think we would, did you want to say something, Herman?
Yeah, I wanted to, I'm sorry, I'll just be very brief. Yes, Cyril, you have raised a very, very interesting issue. And I just want to respond to it for a general thinking of the group. You see, you rightly said, you can't have an invention without an inventor and not allow it to be patented in absence of an inventor. So therefore, we have to interpret the law in a manner in which even AI-generated inventions do get a valid patent. And I think that's how the UK court has interpreted, and even the Federal Court of Australia has said. And there is one thing very interesting. They said, look, ultimately, who decides who is the inventor? It's the applicant, right? If I'm filing an application for a patent, I may determine whether I am the inventor or there is somebody else who is an inventor in absence of somebody disputing it, right? So if there is no AI to dispute that AI is the inventor, an applicant can surely say, I am the inventor, of course, keeping in mind the integrity issue of such statement. Because if the AI is the inventor, can an applicant say, applicant is the inventor? Unless it's a case where the applicant has no role whatsoever to play, in the creation of the invention. But if an applicant has contributed, maybe not in a significant manner, but in some manner to enable an AI to generate an invention, then the applicant can claim himself to be the inventor. I mean, that's how we can address the issue rather than create a kind of quadrum where we don't have an answer. That's all I have to say.
Thanks, Herman. But I think that brings us squarely to the next issue, which is that if we start to recognize AIs as inventors, or even if we don't do that, with AI inventions itself, we have a problem, definitely, in terms of what would be sufficiently inventive. Because AI inventions really challenges the notion of inventiveness that we know. I think in many countries, how inventive an invention is to be patentable is measured by asking whether the invention is one which would be obvious to a person ordinarily skilled in the art. So again, the assessment or the measurement goes back, is assessed vis-a-vis a human inventor. But we all know that with AI inventions, they perform tasks and produce results that are beyond what is achievable by a human inventor. So if we start to say, okay, we can recognize program or AI as an inventor, or so would it mean that all AI inventions would be patentable? Because if we continue to apply the well-established tests of novelty and inventiveness, which are measured against a human person, then invariably an AI invention would be new and novel, will be new and inventive. So, and also it raises the question of the test itself, definitely, but also who should be a person ordinarily skilled in the art? Or is the concept of a person skilled in the art even relevant or appropriate when it comes to AI inventions? So I'd like to put this to all our speakers, and yeah, perhaps Herman, you want to start?
Yeah, sure. So yes, Linda, I think that's a very, very pertinent question that we need to keep into consideration to answer your first question as to who should be the inventor, because I believe there has to be a harmony in the principle that we apply to the whole issue. Now, the test of obviousness or the test of inventive step cannot be different for an AI invention as compared to any other invention. The law does not make any difference. And that will, of course, bring us to the second question: should the law make any difference? Of course, but that is something which we can discuss a bit later. But to my mind, and as the law exists today globally, the test of obviousness has to be the same. Now, let's apply the test of obviousness to an AI invention. To my mind, it is a person of ordinary skill in the art. Question is, who is the person of ordinary skill in the art? Here, then we have to talk about what is the state of art that we are addressing here. And the state of art here, or the field of invention that we are addressing in case of AI, is basically a machine or a software combination with a hardware, which is capable of processing information, data, and generating data or inventions. So all such persons who have that expertise as a skilled person will be considered as the POSA for purposes of AI. Now, naturally, as in all such cases, all patent cases, such POSA will have to be denied the inventive and the imaginative faculty. And then you will have to evaluate whether an invention which is claimed as an invention is obvious to a person skilled in the art, being a software in software development or engineering, no matter whatever name that you may give it. Is it obvious to that person, keeping in mind what is the existing state of art preceding the invention? Now, therefore, we will have to see what is the state of art which existed, what kind of AIs that were known in the public domain in that field of invention. So, for example, if you're talking about plain AI, then we have to look at the known AIs which are there. If you're looking at an AI generated invention, for example, if you're talking about a driverless car, then you also have to examine not only AI but also the cars which are known. So the area which the invention pertains to, along with AI. And therefore, my understanding is that nothing changes in terms of the test. We have to identify what is the state of art and what is the person skilled in the art without imaginative and inventive faculty when it comes to AI, and apply the same test as we have been applying to anything else.
Thank you, Herman. Just a point. I see some participants have raised their hands. Perhaps you can type in your question, or if you have any comments, you can just type those in, and we'll try to take questions at the end of the session. Yeah. Cyril, do you have anything to add, to comment?
Yes. So if you measure an AI invention using the same principle of whether this is obvious to a person skilled in the art, I think patent offices have to be very careful about how this would affect other inventions that do not use or require AI. I mean, if you put human inventions and AI inventions in the same playing field, that would have a very big impact on the standard of inventiveness or non-obviousness. I think first of all, I think we should keep in mind the context. So, over a very long period of time, the standard of a person of ordinary skill in the art has evolved. From decades ago. Now we assume that a person skilled in the art has, access to a computer, to the internet, to certain software programs. But AI is not at that ubiquitous level yet. So I think when considering how to measure the inventiveness of an AI invention, I think the context and certain factors have to be considered. So like in certain specific technical fields, I think AI machines are already being regularly used, such as drug development. So if we're trying to find like a vaccine, and we could just input some data and ask the AI machine to come up with a vaccine solution. That in that field, you can make an argument that this is something, this is a field where AI machines are regularly used, and inventors and researchers and workers, average workers in this field, have access and regular use to such machines. But I think in other fields, I think it would be unfair to apply, would an AI, would it have been able to do this? I think that would be unfair to apply that to other technical fields. So I think the examiner should only consider the capability of AI when determining inventiveness if the AI machine is readily available to someone of ordinary skill in the art in that specific field, and that person is actually able to access and use that AI machine. But I think again, I hate to bring the same point again, but there's a whole spectrum of AI inventions. So I think in 10, 20 years, it's possible that AI machines will be fully accessible and regularly used in all fields. And in that case, I think the standard of person of ordinary skill in the art has to be, it might have to be revised substantially, because in every single context, the examiner will be wondering, wouldn't the AI machine be able to accomplish this task, instead of thinking, would a human of ordinary skill in the art be able to accomplish this task? So the levels of difficulty are just too drastic, or too different.
Thank you. I think that may offer a practical solution, but I think it also introduces an additional layer of inquiry that the examiner as well as the court in an invalidation action has to look into, which is whether AI is readily available in that industry, in that area of field. But it would also, in my view, introduce a little unfairness, because then you have two different standards between those who can afford to use AI and those who can't, bearing in mind that what is inventive should not be differentiated based on where that invention is created, because some nations, some inventors may be in an environment where AI is not so readily available, or even though it may be readily available in, say, another country. But those are definitely points for further thoughts. I'm just wondering, Alexandra, do you have anything you'd like to add or comment on this?
Yeah, hi. I think I can make a couple of very quick points, but they just lead on from what my colleagues here have said, and the fascinating conundrums which are basically being explained and uncovered. First up, I'd say, in response to what Cyril was saying, patent law is quite familiar with the idea of looking at different fields in different contexts with slightly different approaches. So for example, you know, traditionally you go back some years and you had therapeutic types of medical methods for treatment being treated differently from cosmetic types of treatment in some jurisdictions, or software patents being treated having to be looked at differently from some biological patents, because they're different fields, and so that necessarily requires some different types of thinking. So that's not unusual, but I think the problem comes back to this question of needing an even playing field, which not to tilt it in favor of some some types of inventors in some fields, being able to perhaps be able to use AI systems and benefit from them in a way that others might not because of their type of field. Which brings me to the next point, which is a very simple point, but a really big point, which is if these AI systems are available, regardless of your field, and as a result, the system can read everything that was ever published, potentially, compute it all, absorb it all, if we want to use a human analogy, then what happens to our idea of skilled in the art? Because basically everything becomes obvious. And so regardless of whether you are using your AI system as a tool, or you're using it and a tool that you know exactly how it's working, or a tool where you put some parameters in and press a button and it starts computing and churning out outcomes, it's going to be very difficult to try to work out what your person skilled in the art would think of as non-obvious or obvious if everybody has access to these with some degree. I mean, maybe in some fields it'll be more than others. Now that brings me to my third point here, which is not exactly the same as the one Herman was making earlier, but relates to it, and that is the need for honesty. And I think a point has been made in several of the court cases around the world that you might already have AI systems being used in inventive ways, but because so far human beings are needed to be named as the inventor, perhaps there's not so much acknowledgement of how much they've been used. And so if we're going to stick with the current rules, we want to have them being interpreted in a way that people are not being incentivized to somehow obfuscate about how they have invented. And so when I said it comes back to Herman's point, and it's slightly different but related, when he was talking about the self-nominating inventor, you know, when you're putting in the patent application, it's up to the applicant to nominate who it is who has invented, or who or what it is has invented. That's absolutely correct. And that's great and fine and all good if you're talking about the getting the property side of things, you know, what the registration, what in copyright would be called subsistence. You know, first you need to get your property before you have any rights that attach to it. But then when we come to those rights and enforcing those rights, not only do we need to work out how somebody derives title from an AI system if they've been there, if you haven't said, well, our AI system is our inventor, you've put a human in there instead because you want to get around this fear that you might not get your patent if you don't name a human. And then down the track, you sue for infringement. And some clever defendant wants to say, well, sorry, your patent was never valid in the first place. Being able to say that the wrong person applied for the invention, or the wrong person was named as the inventor, might be a problem that would arise then. And you do wonder whether people are going to want to spend a lot of money and time and effort getting their patents if they stand to have them overturned the moment they try to enforce them against somebody.
Yeah, thank you. Thank you so much, Alexandra. I think those are all certainly valid points. There are a number of questions, and I'd like to take some before the session concludes. But before we leave, I'd like maybe for our speakers to maybe just say 1 or 2 sentences on the question of whether you think we need a new type of IP right or patent system that specifically deals with AI inventions and innovations. So what do you think? Maybe just 1 or 2 sentences, and then we'll move on to take some questions.
Well, Linda, if I may go first.
Sure.
I believe that firstly, getting or wishing for a new patent system or a new patent legislation for AI may be a Herculean task. And we are talking about a law which should be harmonized, because we are talking about global rights, inventions, inventors having global rights. As it is, we are finding serious challenge in how to grant a patent in respect of AI inventions. If we start talking in terms of harmonizing and what should be the law, it will be a very, very uphill task, number 1. Number 2, I believe that the existing law are absolutely fine. It's just the manner of adapting the existing legislation, the principles which are well established by the judicial pronouncements over past century, to a new technology. So we are actually looking at a new technology or an invention created by a new technology and how the present law should apply to it. I think it is feasible, it can be done. So in my submission, there is no new law required.
Alexandra?
Well, I might depart slightly from what Herman says. Not necessarily, but probably. I would go back a step, and I would say the first thing to do would be for governments to work out whether they actually want to incentivize AI inventorship in this way, in the way that patents are supposed to do for humans. So I'd go right back to the beginning foundations and say, what are we trying to achieve with our patent system? What are we trying to incentivize, and how are we going to do it? And if it's thought in various jurisdictions, and I think we do need to be careful that there's not pressure on countries to go along with a trend, a global trend that maybe they wouldn't find is in their best interest. There's been a lot of that in intellectual property law in the past that's been heavily criticized in the literature. But if governments decide that it would be in their best interest in their jurisdiction for AI inventorship to be incentivized, then the next step is, how do we do it? And so my second point would be, I would think at this moment we probably would want some sort of sui generis system for AI inventions. We have, plant variety type systems for plant breeders' rights. You have these little type special areas of intellectual property that don't really fit neatly into the patent, design, copyright, trademark quartet of main areas of IP. And I would think that probably we would do better if we created a bespoke type of, a patent-like system, but that looks at exactly what is going on when you have an AI generated invention and try and reward it or incentivize it appropriately according to that particular context. But I agree it would be a Herculean task.
Yeah, I agree that it's probably much more realistic if the current legal systems make baby steps and make little changes to the laws to adapt to AI inventions. I think creating a whole new system or a whole new type of IP right just for AI inventions, first of all, legislatively, that's pretty difficult to do. I mean, just as an example, there's, I think, for lawyers, there's still no universally recognized definition of AI. Like even that one little thing is already, takes a lot of work for people to come together and agree on one little thing. So I think it's very hard to actually have legislation on a new IP right. But even assuming that it can be done, those would be still utility patents. So if you have two if you have like regular utility patents and AI utility patents, like what, I mean, how would that affect the regular utility patents? I mean, are examiners not allowed to imagine, compare whether, this act can be achieved using AI? So is it just gonna be like the examiner's not allowed to consider AI, even if AI becomes so commonly used? So I think if AI inventions become more and more advanced and start, coming up with solutions on its own, I think all the standards will eventually just evolve along with the technology. And if we create a new system now, I think it would kind of disrupt a lot of things. And I think it's better for the law to just kind of try to adapt gradually instead of drastically create a new system.
Definitely, those very good points. But I think for the time being, if we keep to the present laws and method of evaluation, it's almost impossible to invalidate AI inventions actually based on what we have now. So let's take some questions, and this will be for all the speakers. So the first question is, wouldn't the judicial incentive to invent, as alluded to by Hemant, be passed to the owner of the AI software or hardware? So in a sense, it is no different. Maybe Hemant, do you want to comment?
I'm sorry, I've not been able to understand the question, Linda.
The question, so I'll read it again. The question is, would not the judicial incentive to invent, as you mentioned just now, be passed to the owner of the AI software or hardware? So in a sense, it is no different. So I guess what the question is saying is that in terms of AI inventions and the incentive to invent, really, I mean, that's why companies put so much investment and so much money into creating AI programs. For example, the Davos case, that's what they do. They use AI to create something. Presumably, it's just like Halicin, the drug. The AI program, the people who write the program are not the one, I suppose, who thought of the problem and want to find a solution. I think very often the scenario or the situation will be that pharmaceutical company, maybe like for pharma type of inventions, these are the companies who will be interested to engage with an AI company to create an AI program that will help them to come to an invention that they can later commercially exploit. So that incentive to invent would still be there and not diminished just because it is an AI invention. So any comments to that?
Yeah, absolutely correct. There is no dispute there. And that's what I said, if I remember correctly, that ultimately we have to interpret the law so that the ultimate objective is not defeated, which is the inventors or those who are using inventors to invent, so that they can derive benefit from it, should have the incentive to secure a right. Now, therefore, how will that happen unless you have the assignment of right from an inventor to an applicant? So as you gave an example of a company engages an AI company or AI person to invent, right? Now that person or that company is the inventor. If that company is the inventor, the rights have to be assigned to the client, who has engaged them as a professional services. It's only then that client can claim a right in respect of that product. So if I've understood the question, it's also in order to ensure that incentive, that reward remains and it doesn't become a disqualifying factor that because AI is a machine is an inventor, therefore the individual is not an inventor, therefore the assignment of right is not valid, therefore there is no valid patent. It will kind of go into a cycle where it will be difficult to maintain the validity of a patent. And if you're not able to maintain the validity of a patent which is generated by an AI, the incentive is gone.
Right. So next question. I think this touches on the point that Cyril, you mentioned earlier, where we are not there yet, but looks like we will get to a stage where we have an invention created by AI, or the most part of it. So the question is, who owns a novel and non-obvious invention created by only AI, no human inventor involved, and why should it not get patent protection? By reason only that it is by reason that it is created by AI only, or through AI effort.
I think the laws would have to adapt to that situation. So currently, in that situation, an inventor cannot be named. But if the AI machine can be listed as the inventor, I think the inventorship and the ownership can be separate, I think. So you can list the AI as the inventor, because that is who conceived the invention. But the ownership, the owner can be the patent owner can be, for example, the owner of the AI machine, or it could be the programmer. I mean, that I think that's a further other discussion. But I think in that situation, if there are no rules or laws for deciding who is the owner, maybe parties have to, the ownership has to be clarified by contract, maybe. So just as an example, so like if a company built an AI machine and a healthcare company gets a license and uses that AI machine and inputs its own information. So the healthcare company has its own information that it obtained and puts it into the AI machine, and the AI machine outputs an innovative solution. So in that case, who would own the patent to that solution? Would it be the owner of the AI machine, or would it be the healthcare company, or the team that obtain the data and try to train the AI machine to use the data? In that case, maybe a contract between the owner of the AI machine and the healthcare company would resolve the situation, rather than relying on waiting for laws to catch up.
Thank you so much. Well, we've come to the end of the session. It's already up our hour. So I want to say thank you very much again to all our speakers, Herman, Cyril, Alexandra, for all the knowledge and experience that you have brought to this discussion today. I also want to thank everyone for attending this session. So sorry that we are not able to cover so many questions, but we'll try to follow up on them. So thank you very much again, everyone. Thank you, and have a good day for the rest of the day. Thank you. Bye-bye.
Thank you, Linda. Thank you,
Linda. Thank you, everyone.
Thank you. Bye-bye.
Bye-bye.